Truly, hey, are you okay that you're moving tomorrow?
Yeah.
Are you excited?
Yeah.
Okay, all right. You know, once again, I in my state of bitterness, I'm trying to box Christine in. I think she's doing something wrong. You sure? Where's your smile? No smiles about it, huh? Sorry. All right. Well, I'm in a really bad state of mind. I feel like my life is being unraveled for me. This isn't something I want. I feel out of control.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. It is Friday, December 20th, 2024. I hope you are having a wonderful day. Well, I finally got news from Utah courts about what's going on with Cody and Christine's case. And it was an interesting development because on the one hand, it would appear that this isn't a highly disputed, contentious hearing or contentious dispute. But on the other hand, it appears that on the horizon, there could be a possibility that this becomes contentious and becomes more complicated than it is, because the ruling from the court was sort of a mixed bag. And let's kind of talk about what happened. So, 2 days ago, Cody and Christine sat in court in Utah County and sat before Commissioner Snow to discuss what their plans were for moving forward in this dispute over custody and paternity related to Truly Brown. We don't know the full scope of this case, but we do know a few details. Christine initially filed her case on September 16th, 2024, seeking paternity, child support, and custody related to their daughter, Truly. It is unknown if this case also is related to child support related to Isabel Brown, which would still be a possibility because she is 21 years old and you can go back 4 years. Now, Cody responded with his own filing on the October 23rd, 2024. And by December 18th, they sat in court in a closed hearing. And interestingly, the order from the court is public. So what is it that the court found? So the matter came before the court on December 18th, 2024, for the purpose of a Rule 100A case management conference. Now, this is where it gets a little weird because the record says in the marriage of Christine Woolley and Cody Brown, in the marriage. So it's a divorce. Paternity cases in the state of Utah do not automatically mean that a divorce has happened. In fact, unmarried parents can file paternity cases and child custody cases. So the fact that this is being treated as a divorce in the state of Utah, I have a lot of questions here, and I'm starting to wonder if this is why the case was closed. Were there multiple marriage licenses that we didn't know about? Is that why this is happening? This is wild. They took a look at two things. There was one or the other. The parties state they have heard, understood, and agreed to be bound by the terms of the stipulation read on record. The court accepts the stipulation and resolves the issues between the parties, and no issues are reserved for trial. Or they are going to set this matter on a track. So interestingly, they have set this on for the track 1 standard track. This means the court finds this case does not require expert witnesses or complex discovery and orders discovery to be completed pursuant to URCP Rule 26 and 26.1. Given Cody's behavior online on the show and to the public in general, I had thought maybe there was going to be a dispute of track 3, meaning that there could have been some level of child abuse or domestic violence, but the court is not having it sit at a track 3. But interestingly, they are making stipulations for a custody evaluator and a possible guardian ad litem. So they did find that the parties had already completed their initial disclosures. So each side has provided information to the other about finances and what they're looking for from the other for discovery. And then they have until May 15th, 2025 to complete domestic relations actions of Tier 4 discovery. And interestingly, it says a custody evaluation may be necessary in this case. The parties may file the appropriate motion by April 1st, 2025 for a URCP Rule 101 hearing before the commissioner. If either party requests the appointment of a custody evaluator after this date, they must show good cause as to why they failed to meet the deadline. So there's a possibility here that one or the other, whether it's Christine or Cody, their attorney said that they may consider the need of a custody evaluator. And a custody evaluator is someone that is a neutral third party that looks at both parents, and they will take into consideration the environment in which the child would live. And they are going to be looking at who the minor child has who they've spent the most time with. They're going to be looking at which parent can meet physical needs, emotional needs, educational needs, medical needs, special needs. They might be looking at a parent's capacity and willingness to function as a parent, including parenting skills, ability to appropriately communicate with the other parent, ability to encourage the sharing of love and affection, willingness to allow frequent and continuous contact between the minor and the other parent, any past conduct demonstrated moral character of the parent as described, the emotional stability of the parent, their inability to function as a parent because of any drug use or drinking, parents' reason for having relinquished custody or part-time in the past, duration and depth of desire for custody or parent time, their religious compatibility with the minor child, the parent's financial responsibility, interactions and relationships with step-parents, who has been the primary caretaker of the child, previous parenting relationships in which the minor child was happy and well-adjusted, the stated wishes and concerns of the minor child, and the relative strength of the minor child's bond with the parent. Depending on what they find out, the minor child might have to testify if they work with a custody evaluator to help them better determine what everything looks like. But, they can look at a lot of different issues for Cody and for Christine. So either one of them will be able to do a evaluation process. And I don't know if they will, but I thought that was an interesting ad because generally the custody evaluation and the guardian ad litem are added on the track 3. So that's why I think there's a possibility this could become more contentious in the future. But for now, it is listed as track 1. And then it also says that a private guardian ad litem may be necessary in the case. And it says the parties may file the appropriate motion by April 1st, 2025, hearing before the commissioner if either party requests the appointment of a private guardian ad litem after this date. They must show good cause to meet that deadline. So on the one hand, there is this assumption that this doesn't have a significant custody dispute and it won't require expert witnesses and it's not going to request complex discovery. But then on the other hand, if a child evaluator gets in place and a guardian ad litem comes into place, that could seemingly cause this to become more of a complex case. And if a guardian ad litem is involved, they would be serving sort of as the expert for the child and what is in the child's best interest. And according to Utah Child Custody, a private guardian ad litem in family court, a guardian ad litem is an attorney appointed by the court to be an independent investigator who can propose solutions that would be in the best interest of the child. If the court-appointed attorney's recommendation is in conflict with the child's wishes, then the GAL has to represent both their recommendation and the child's wishes. So they're appointed by the court. There's a list of eligible ones that can be selected. It says both parties would be responsible to pay. And what are the obligations of the private GAL? It says they represent the best interests of the child. They conduct independent investigations to have a clear understanding of the child's situation and needs. They conduct witness interviews and evaluate records related to their child and the family. They personally meet and interview the child if no statutory exceptions apply. They determine the child's goals and concerns about custody and visitation. They keep the child advised on what's happening in their case. They attend hearings and conferences and present witnesses and exhibits to protect the best interests of the child. They identify and advocate for community resources that protect the child's best interests, and they participate in all appeals unless excused by the court. So they're basically there to serve as the child's advocate and verify and determine where there's a complicated custody dispute. What are the child's needs? What's the best interest of the child? And they're removing themselves from mom or dad. And they're looking at this as a neutral, what's best for Truly. I honestly couldn't see how this would be a bad thing, honestly, given how complicated the relationship dynamic is here and the history of Kody with his children, especially the fact that Christine moved to Utah 3 years ago. And in that 3 years, Kody has not maintained consistent contact with her. He hasn't made that much of an effort to see her regularly, communicate with her regularly, or be a present, engaged father in her life, whether it's in school, health decisions, life decisions. And at this point in time, he hasn't even been established as the father. So even though it's assumed that he is the biological father, he has not had any biological father rights because, technically speaking, he's not on her birth certificate. Legally, he hasn't been deemed her father, and so he has no parental rights. Christine has been able to make all the decisions herself. Once paternity is established, then Kody has legal rights. The question at hand here for me is that if Kody really did care about his daughter, why didn't Kody initiate paternity right away? Why didn't he go through the steps to become legally a father to Truly? If he truly cared, why did he wait until Christine filed for paternity and child support to then do a counterclaim against her? It almost feels like it's a little bit reactionary here because had he done it the other way, he would have had more of an upper hand, showing like, hey, I do want to be an engaged father. I want to have choices legally for my child. I want to be engaged in the decision making surrounding her schooling and her health care and her social activities. But he didn't do any of those things. It would be interesting to see from a perspective of a guardian ad litem how they would factor in the complicated family dynamics here of what was once they were part of a polygamous cult and dad was a practicing polygamist and had 4 wives to now dad claiming that he is a monogamist and he has been an active and engaged father with children that are also minors close in age to Truly, and he has been a decision maker. He has provided health care. He has paid for their schooling and for their lives. He has provided stable housing for those kids. But then when it comes to Christine's daughter, Truly, he hasn't done any of those things. You know, since Kody and Robin became legally married in 2015, Kody and Robin, their children have been on Kody's health insurance. Kody has paid mortgages for Robin's home. Kody has taken care of the responsibilities for Robin's kids. He has been someone that has taken his kids, Ariella and Solomon, regularly to and from school. He has been engaged in that process the whole time. And so my question for Kody or for a guardian ad litem or whoever would be, why was it that you were able to do those things for these kids when you were married to Robin, but you were claiming to have this consensual, mutual relationship with Christine, and those same responsibilities weren't granted to Truly? Why was it that in the course of your relationship with Christine, you never sought paternity? Why is it that you never sought paternity? Is it that you were trying to avoid child support? Was it that you were using the system so that Christine didn't have to claim a father so she could get welfare, food stamps, Medicaid? And if that's the case, that almost feels like it would be an abuse of the system. And at one point in time, Christine did receive Medicaid and food stamps for her kids. It's unclear at what point she stopped using that. We don't know after 2010. We know in 2010, when she filed bankruptcy, she was receiving food stamps, but we don't know after that if she was receiving food stamps or Medicaid for her kids. But why, again, did Kody have this child who Christine birthed on television, and then he never actually claimed the child? my question would be for like the doctors and the hospital that had this on and at their hospital, why were they allowed to leave the hospital with the birth certificate without Cody on the birth certificate? He was there claiming to be dad at the birth. He was there acting as dad at the birth. He was there saying it was his child at the birth. And then when the documents were filed for the birth certificate, he's not on the birth certificate. Why was that allowed to happen? Only because she was single? And if she did ever receive any aid from Utah for Medicaid or welfare for Truly, the responsibility does not fall on her to repay back the state. It would fall on Cody. It's highly unlikely that she gets any aid now. She's far exceeds income. She bought a $750,000 home a couple years ago. She has an investment rental now. David has a home. They have money now. But why didn't Cody claim her then? And then why now is he fighting her? It just doesn't make sense to me, other than he's being a jerk. Now, they are also going to be required to do the court orders that they have to complete mandatory educational and orientational classes for divorcing parents, and they have to submit their certificates of completion 30 days from today's hearing. So both of them need to complete their parenting time classes. They are being ordered to do mediation and have it completed by May 15th. They do not anticipate that there would be any temporary orders in the case, meaning like a temporary agreement on custody. And they are scheduling a Rule 100A pretrial before the commissioner is scheduled for May 21st, 2025. And it says that failure to appear may result in your pleadings being stricken and or default being entered. And it's interesting because they didn't click on track 1 pretrial. So there was an option where they would have a track 1, which would be a Rule 100 pretrial before the commission is not required if mediation between the parties is unsuccessful. This space intentionally left blank is to provide the list of claims that the opposing side no later than 1 week after mediation. So they are requiring them to do a pretrial hearing with the commissioner on May 21st, even if mediation is unsuccessful. So it's like, on the one hand, it's a track 1, but on the other hand, it's like not a track 1. It's very strange, honestly. And I think it could partially be coming down to how well they're able to, the two sides, the lawyers, to negotiate what is in the best interest of Truly. If I were Christine, and this is just me, if I had concerns about Cody's possible drinking or his stability, his mental stability, I think having a custody evaluator would be a great thing. You'd be able to see Cody's house, what's going on in his and a third party would be able to review him, not like, some weird anthropologist people that come in because of TLC, right? Like a person that has the interest of the child at heart there, right? And given that Truly has such an estranged relationship with Cody, honestly, a guardian ad litem might not be a bad thing. And the fact that Truly has a new stepfather, it might also not be bad for her to have a guardian ad litem, because she'll be able to speak to someone that's not mom, not dad, and be able to share and express her concerns to someone that will listen to her and not have to feel bad about it. Like if she wants to, maybe she's afraid to be honest with Christine about something. Maybe she feels uncomfortable talking to Cody, and that's where a guardian ad litem can be really beneficial for the child. And even though she's 14 or 15 at the time this all goes down, it's still good for her to have one, in my opinion. I think Cody needs a mental health evaluation, to be honest, but that's just me. Finally, I did a little bit of digging while we were recording this video, and I noticed that in Utah, it says even if a couple is unmarried, a child custody case might be listed as a divorce because the state's legal framework for child custody largely operates under the same rules as a divorce case, meaning the court uses the same procedures and factors to determine custody even when there was no marriage to dissolve. The key difference is that the court cannot issue a formal divorce decree in such a situation, but still needs to establish paternity and decide custody arrangements categorized as a divorce case. It's not technically a divorce, but the court will use the same factors to determine custody. And there is likely no property division. So that could be why they have it listed as a divorce, or it could be something else. I don't know. But if you've had a case in Utah, well, let me know if this is how it's been viewed for you. Also, what are your thoughts about the ruling of the court and the ruling of the judge? Do you think it'll become more of a complex case? What are your thoughts about a guardian ad litem or a custody evaluator? And do you think they will be able to come to an agreement without going to trial, or do you think this will become more contentious? Let me know your thoughts in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Bye, everyone.